A legal battle is brewing between a corporate giant and a state, and it's not just about the environment, but also free speech. Exxon, a major player in the oil industry, is taking on California's climate laws, claiming they stifle corporate expression. But is this a genuine concern for free speech or a strategic move to avoid accountability? Exxon, a company with a significant carbon footprint, is challenging two California laws aimed at addressing climate change. These laws, part of the California Climate Accountability Package, mandate that companies operating in the state disclose their carbon emissions and climate-related financial risks, or face penalties. Exxon argues that this is a violation of their right to free speech, as it forces them to endorse views they disagree with. The lawsuit, filed in a U.S. district court, claims that Exxon already voluntarily reports emissions and climate risks using its own methods. However, the California laws would mandate the use of specific frameworks for emissions and risk reporting, which Exxon considers inaccurate and counterproductive. This raises the question: should companies be allowed to choose how they report their environmental impact? Or should there be standardized methods to ensure transparency? Exxon's preferred emissions calculation method is provided by IPACA, an industry association, but California's laws require the use of the Greenhouse Gas Protocol, a methodology developed by independent research and business groups. Exxon believes this framework unfairly blames large companies for climate change, regardless of their efficiency in meeting energy demands. Another point of contention is the scope of emissions reporting. Exxon argues that it should only report emissions from activities within California, as most of its operations are outside the state. Additionally, they claim that disclosing climate risks to their business is speculative and conflicts with existing federal securities laws. Supporters of California's laws see them as a way to prevent companies from greenwashing. They believe these regulations will expose the true environmental impact of major polluters. However, Exxon argues that the laws are an overreach designed to manipulate public opinion and target specific companies. But here's where it gets controversial. This isn't the first legal challenge to these laws. Business groups have previously sued California over the same regulations, and the case is ongoing. The U.S. Securities and Exchange Commission also attempted to implement similar federal rules, but faced legal obstacles and ultimately backed down. What do you think? Are Exxon's concerns about free speech valid, or is this a strategic move to avoid environmental accountability? The debate continues, and it's a complex issue that highlights the tension between corporate rights and environmental responsibility.